Now, if your spouse had children from a prior relationship and they pass away without a will, then by default, those laws of intestacy, half goes to their children and half would go to their spouse. Now, this can be a devastating result. I've seen it happen several times. Recently we had a lady lost her husband, passed away. Only asset was the house. There was a mortgage on it. There was some equity there. She was living in it and was able to afford the payments, but we had the problem of the other beneficiaries. They're entitled to half of that house. I think it had to be sold so that she could share half of that with them. She didn't have any other assets to pay them their share. If that's your situation, if you're married and your partner has children from a prior relationship and you haven't done your last will and testament, you should go ahead and write something by hand right away. So if you want to make sure your partner is protected, you can do what's called a holographic will, handwritten, where you write it out on paper. Also, if you're not legally married, so if what you would consider your partner, significant other, whatever you want to call it, if the law doesn't recognize your relationship, then if you pass away, one passes away, the other person has no rights. So again, that's an important situation that you want to make sure that we plan for. Something else too is your children. So if you have children that aren't legally adopted by you, maybe they were your partner's children when you got married, they could have been in your life, forever, but they weren't legally born to you and legally adopted by you, then there's no rights for them as well. So that's an important situation when you would want to update your plan and even do a handwritten holographic will to make sure they're protected. Let us know if there's any topics that you'd like to hear us discuss. And thank you everyone for tuning in. Have a great day.